Hi all, I'm Abhishek. Welcome to the Nationalist Post. Today we'll be talking about the hijab law that has been in the news since December 2022. It has been more than 10 months. It is questioning two fundamental rights of the Constitution, that is Article 21 and Article 25. What is greater? Article 21, which gives you freedom to life, or Article 25, which gives you freedom to practice your own religion at your own leisure. These are two main articles that has been under question by the people as well as by the court. Recently, on the 13th of October 2022, the Supreme Court went on a split verdict, which we'll be talking about more at the end of the video. But today, we'll be talking about the timeline from December 2021, on the day this issue started, till 13th of October 2022, on the day on which Supreme Court, a two-bench judge of the Supreme Court, arrived on a split verdict. So, let's start into this video. This controversy started on the last week of December 2021 when 6 Muslim students of the state-run Udupi Women's PU College claimed that they were not allowed to enter the classroom for wearing hijab. The students stood outside the classroom for days in protest, claiming that though their parents approached the principal for talks, he refused to discuss on this issue. And this same statement has been refuted by the principal too. Now, from the end of the last week of December till January 13th, many students wore saffron scarves to display a tit-for-tat condition. On January 14th, protesting female students in Udupi accused their principal for not allowing them to attend their classes because they were wearing hijab. Principal refuted this claim. He told that the students were under the influence of some vested interest groups. On January 26, the Karnataka Education Department decided to form a committee to come up with the guidelines on uniforms for the PU colleges across the state. The PU board asked colleges to maintain a status quo until the new guidelines are formulated. The NHRC on the 27th of January, that is the National Human Rights Commission, raised concerns of violation of right to education and asked the Karnataka government to take an action immediately concerning that there is a grave violation of human rights. On January 31st, President of the College Development and Management Committee and MLA of Udupi, K. Raghupati Bhatt, held a meeting with students' parents and conveyed to them that students will not be allowed to wear hijab inside the classroom. He also ordered that there should be no activism inside the campus. On the same day, one of the Muslim students of the Udupi College approached the Karnataka High Court seeking interim relief to attend classes wearing hijab. The writ petition filed on behalf of student Reshma Farooq said the student's right to wear hijab is a fundamental right guaranteed by Article 14 and 25 of the Constitution, and it is an essential part of Islam which is still under question. This has again been debated on the Karnataka High Court as well as on the Supreme Court. Since then, clash has been spilling all over the parts of states, leading to standoffs and clashes among students of different faith. Now again, if we fast forward to February 7th, students clad in burqa who were allowed into the PU college were not seated on the same classrooms as their peers. They were seated on a separate classroom. On February 8th, Chief Minister Basavaraj Bommai said that all high schools and college will be remain shut to maintain peace and harmony for 3 days. Again, on February 14, Section 144 was imposed to maintain peace and tranquility in some places of the state. On February 20th, 26-year-old Bajrang Dal activist Harsha was hacked to death, which further fueled the communal tensions in the state. On March 20th, a full judge bench with Justice Rituraj Avasthi, J.M. Kazi and Krishnan Dikshit upheld the government's decision on hijab ban. State told that it is not an essential part of Islam. That is, the bench came to a conclusion that wearing hijab is not an essential practice in Islam. Now, after several pleas and petitions were placed in front of the Supreme Court on this issue since that day, some have been accepted by the Supreme Court and has been looked into. The communal clashes continued across several months in remote places of the state. On October 13th, The bench of Justice Hemant Gupta and Sudhanshu Dhulaiya of the Supreme Court gave a split verdict on this case. Justice Hemant dismissed the 26 appeals filed against the judgment of the Karnataka High Court, which held that hijab was not an essential practice of Islam and allowed the ban on wearing headscarf in the educational institution of the state. On the contrary, Justice Dhulaiya's statement runs as follows. The thing which was uppermost in mind was the education of girl child. It is a common knowledge that a girl child, primarily in rural and semi-rural areas, has a lot of difficulties. They have to do daily chores before she goes to school and many more. There are other difficulties as well. Are we making her life any better? These are the questions in my mind. This was the verdict that was reached by the Supreme Court on 13th of October. As the verdict was a split verdict, that is one-on-one verdict, there is no conclusion on this case. This case has been forwarded to the Chief Justice of India. Now again, there are two ways that it can go. Either Chief Justice of India can take a 5-judge bench or 11-judge bench, upon which this case will be discussed and a conclusion will be reached soon. This is the timeline that this case has been following since the last week of December till 13th of October 2022. For further updates, we'll be posting regularly on this channel. Kindly subscribe, like, and click on the bell icon to get more updates on such cases. Thank you.